Welcome back, USA Report. At 6:42 a.m. Eastern Time, the first rays of light barely touched the lawns of Mara Lago when United States Marshals quietly arrived, federal arrest warrant in hand, ready to take the defendant into custody. The scene was eerily calm. No media throngs, no shouting, just the meticulous precision of federal law enforcement executing a plan years in the making. Meanwhile, only 300 meters north in West Palm Beach, Melania Trump was stepping into a federal courthouse under her immunity agreement, her steps measured, her posture composed, unaware to casual observers of the extraordinary synchronization unfolding. Her husband, a former president, was moments away from being handcuffed while she was being sworn in. A juxtaposition so stark it reads like a cinematic thriller. That timing wasn't accidental. It was deliberate. A prosecutorial strategy designed to ensure absolute control over the narrative and, more importantly, the testimony itself. Within minutes, the Marshals had served the warrant without incident, handcuffed him, and transported him under secure federal custody to the Miami Federal Courthouse holding facility. By 1 p.m. that afternoon, he would stand before a magistrate judge facing 46 federal counts, 12 more than the original indictment, 12 more counts tied directly to what Melania had revealed moments earlier under oath. The orchestration of this morning was surgical, a high-stakes chess match between prosecutors and one of the most scrutinized figures in recent history, and every movement was calculated with precision. Before anyone assumes chaos or political theater, the story is one of methodical legal strategy, evidence-driven decisions, and an extraordinary alignment of timing. The coordination began hours before dawn. At 6 a.m., Melania's legal team arrived at the West Palm Beach Federal Courthouse to finalize the immunity agreement. Prosecutors reviewed every detail with her attorneys, confirming she understood the implications. Truthful testimony in exchange for pleading guilty to one count with a recommended probationary sentence. Every word was deliberate, every acknowledgement documented. By 6:42, Marshals arrived at Mara Lago, carrying the arrest warrant signed just the night before by a magistrate judge. Secret Service officers coordinated seamlessly, ensuring that the operation proceeded without confrontation or spectacle. By 6:47, the defendant was in custody, handcuffed, attorneys notified, and preparations underway for the transport to Miami. Within minutes, he was on the move, the legal machinery of the federal system quietly humming in the background, unnoticed by most, but with consequences that would ripple through headlines and courtrooms alike. By 7:15 a.m., he was being processed in Miami, photographed, fingerprinted, and secured within the federal courthouse holding facility, while Melania, just blocks away, prepared to enter the grand jury room. The distance between them, just 300 meters, belied the strategic significance of their positions. Once she took the oath, there was no chance for him to communicate, interfere, or attempt to influence her testimony. Every phone call, message, and intermediary contact was cut off by the simple fact of federal custody. Prosecutors had anticipated potential interference and neutralized it before a single word could be spoken under oath. This was not mere coincidence. This was legal precision at its finest. The last 6 hours had been choreographed to perfection, from arrival times to witness readiness, ensuring maximum evidentiary impact. At 8 a.m., the grand jury proceedings commenced. Melania began providing testimony under oath, a process that would stretch over 4 hours, dissecting financial documents, property valuations, and recordings she had previously turned over to federal investigators. Every detail mattered, every recollection meticulously documented, and every nuance of her testimony could, and likely would, shape the outcome of the superseding indictment. By 9:30, a recess allowed prosecutors to evaluate the information already provided, consulting among themselves to determine if new charges should be added. The timing of the arrest ensured that nothing she revealed could be compromised, influenced, or challenged in real time by the defendant. When the grand jury reconvened at 10:45 a.m., her focus shifted to highly specific financial communications, phone calls, email records, and documentation surrounding property appraisals. For months, prosecutors had gathered evidence, but her testimony offered the critical connective tissue to prove that the defendant did not act alone. 4 hours later, her testimony concluded, and the grand jury began deliberating on a superseding indictment, reviewing both her testimony and corroborating documents. 1 hour later, they voted unanimously to approve 12 additional federal counts, solidifying a total of 46 charges, each meticulously documented, each tied to evidence she personally supplied. The arraignment, scheduled for 1 p.m., would bring the defendant face-to-face with a magistrate judge, facing the culmination of decades of alleged fraudulent conduct now framed within 46 federal counts. The orchestration of arrest and testimony was no accident. It reflected an intense focus on controlling evidence flow, ensuring integrity, and maximizing the prosecution's leverage. Every movement this morning told a story of deliberate strategy, high-stakes timing, and the extraordinary power of a cooperating witness. But beyond the mechanics of law enforcement, the morning revealed character, instincts, and reactions under pressure. The defendant, placed in handcuffs, transported under federal custody, faced reality in ways that a public spectacle cannot fully convey. Melania, giving testimony, exercised careful precision, balancing legal strategy with self-preservation. The tension between their positions, a literal physical separation of just 300 meters, underscored the stakes: influence, testimony, cooperation, and credibility. In these moments, the human dimension of the legal system emerges, showing the complex interplay between strategy, leverage, and moral choices. For viewers and followers of this case, understanding the sequence, precision, and strategy of this morning is critical. This was not a random arrest. It was the result of years of evidence collection, witness cooperation, and prosecutorial foresight. Every second, every decision, and every document presented today contributes to a narrative that will unfold over months, potentially years. As the arraignment approaches, the implications are clear. The system works methodically when evidence drives action, and every move today was designed to protect the integrity of testimony, ensure fairness in process, and prepare for a courtroom showdown that may reshape legal precedents in white-collar prosecutions. As the superseding indictment landed in federal court files this morning, it was not just another piece of paper, it was a seismic shift in legal strategy, a meticulously documented roadmap that expanded the defendant's exposure from 34 to 46 federal counts, 12 of which emerged directly from Melania's testimony, recordings, and documents. These new charges were not speculative. They were hard evidence, meticulously detailed, each count a thread in a larger web of alleged conspiracy and financial misconduct. 6 counts of conspiracy to commit bank fraud stand out, not just for their legal implications, but because they reveal the necessity of a second participant, someone with firsthand knowledge to testify about discussions, instructions, and approvals. Without Melania's testimony, proving that these fraudulent schemes were orchestrated jointly would have been near impossible. Oh, she had been present for calls with bankers, signed documents listing inflated asset values, and benefited financially from the very loans under scrutiny, making her role central to establishing intent and participation. Conspiracy in federal law requires 2 or more actors, an agreement, and overt acts. The evidence she provided checks every box, and every word she spoke under oath tightened the prosecutorial noose. The 4 counts of wire fraud further demonstrate the precision of this case. Wire fraud, under Title 18, Section 1343, is triggered whenever electronic communications are used to perpetuate a scheme. In this case, emails and electronic submissions containing falsified property valuations and financial statements were flagged, documented, and traced. Each electronic transfer becomes a separate count, and prosecutors identified 4 key transmissions that illustrated the defendant's direct involvement and knowledge. Text messages, emails, and submitted documents all create a digital paper trail, impossible to ignore, impossible to reinterpret. They show methodical planning, coordination, and intent. Every transaction, every communication, every digital footprint becomes a brick in the evidentiary wall prosecutors are building. 2 counts of making false statements to financial institutions under Section 1014 are equally significant. These charges target specific loan applications, the details of which Melania was intimately familiar with. Each document submitted contained inflated property values meant to secure loans under false pretenses, and her testimony, supported by notes and recordings, confirmed the defendant's instructions and awareness. Federal law treats each false submission as a distinct count, meaning that even a handful of documents can multiply into significant legal jeopardy. These counts are not hypothetical. They are concrete, linked to dates, amounts, and communications that the grand jury has now formally recognized as criminal acts. Superseding indictments like the one issued today are a critical tool in federal prosecution. They don't replace the original charges. They expand upon them, incorporating new evidence that emerges after the original indictment. In this case, Melania's cooperation supplied the missing pieces needed to substantiate additional counts. Her recordings of phone calls, her texts, her handwritten notes, all confirmed elements of intent, participation, and orchestration. The grand jury, after 4 hours of testimony and a 1-hour deliberation, unanimously voted to add these 12 new charges, signaling not just the strength of her testimony, testimony, but the prosecutorial confidence in the evidence. Each additional count increases potential sentencing exposure, magnifies courtroom stakes, and shifts negotiation leverage firmly into the hands of prosecutors. The gravity of these charges cannot be overstated. Conspiracy counts carry up to 30 years per count, wire fraud up to 20 years, false statements up to 30 years. While sentencing guidelines allow for concurrent calculations, the cumulative risk for someone facing multiple counts is astronomical. Decades of exposure for acts that prosecutors argue were intentional, coordinated, and repeated. These numbers aren't abstract. They are calculated consequences designed to weigh on the defendant, influence legal strategy, and shape the calculus of plea negotiations. Prosecutors rarely file counts without careful consideration. Every added charge represents not only evidence, but a strategic lever in the broader pursuit of justice. Beyond the legal mechanics, the evidence supplied by Melania provides an unprecedented window into the defendant's intentions, decision-making, and thought process. Recorded conversations from March 2020 show him explicitly discussing inflated property valuations with a Deutsche Bank loan officer, noting that an independent appraisal was low and that another higher appraisal should be submitted. These are not ambiguous statements. They are direct, unambiguous evidence of intent to defraud. Add to that the 2018 text exchanges between the couple, in which he instructs her to report conflicting values to banks and tax authorities, coupled with her cautioning about legality, and the narrative of consciousness of guilt emerges clearly. This is corroborated by handwritten notes from 2019 meetings detailing instructions to prepare 2 sets of financial statements, one for bank applications, one for tax purposes, a deliberate strategy designed to deceive multiple institutions. The precision, consistency, and multiplicity of sources elevate her testimony from mere narrative to irrefutable evidentiary force. All of this, of course, existed within a highly strategic framework orchestrated by federal prosecutors. Timing, coordination, and sequencing of testimony and arrest were executed with precision. By waiting until she was under oath, they neutralized any risk of interference, pressure, or influence. The morning's events were a testament to meticulous planning, highlighting the interplay between evidence collection, legal strategy, and courtroom dynamics. For those watching from afar, it reads like a legal thriller, a coordinated arrest, a cooperating spouse revealing decades of alleged misconduct, and the judicial system moving with methodical, relentless efficiency. The morning was not just about what happened. It was about how it happened, why it happened, and what it signals for the unfolding legal drama. When you think about legal battles, what often gets lost in the headlines is the quiet, behind-the-scenes work that makes or breaks a case. And today, as the defendant faces 46 counts, the pivotal role Melania played in shaping the charges cannot be overstated. It wasn't just her testimony that provided the smoking gun. It was the raw, unvarnished evidence she brought into that grand jury room. For a prosecutor, there is no gift more powerful than a cooperating witness who provides not just testimony, but corroborating evidence. Direct, hard evidence that paints a clear picture of criminal intent. Melania's contribution didn't just add weight to the allegations. It transformed the case from one based on circumstantial evidence to one fortified by undeniable, indisputable facts. Take the first bombshell, a recorded phone conversation from March 2020. A conversation so revealing that it could be considered the backbone of the entire case. In the recording, Melania captured her husband discussing property valuations with a Deutsche Bank loan officer. But this wasn't a casual conversation about market trends. This was a calculated discussion about inflating the value of one of the most iconic properties in the world, Mara Lago. The appraiser had valued the property at $75 million, but that wasn't enough. The defendant insisted they would get our guy to do another one at the right number, meaning they would commission a new appraisal, one that would push the property's value up to $739 million. The intent is clear, the deception explicit. This wasn't a misunderstanding or a mistake. This was a deliberate, coordinated act of fraud caught on tape, with the defendant's voice clearly articulating his plan, no ambiguity, no room for doubt. The recording is damning, and in a case where proving intent is the hardest hurdle, this evidence is a game changer. Then there are the text messages from 2018 which speak volumes about the defendant's mindset. In one exchange, he instructs Melania to tell the accountant to bank appraisal high, tax appraisal low, standard practice. It's the kind of message that might seem innocuous at first glance, but when you dig deeper, it reveals a pattern of behavior rooted in deception. Melania's response, "Are you sure this is legal?" might seem like an outlier, a moment of doubt, but it underscores the defendant's knowledge that what they were doing was not just unethical, but likely illegal. His response, "Everyone does it. Just don't put it in writing after this," speaks to a mentality of evading accountability while continuing to play the game. This wasn't just a spur-of-the-moment decision. It was a deliberate strategy to manipulate financial institutions. He knew it wasn't just morally wrong. It was legally risky. And still he pressed on, with Melania by his side, complicit in the execution of this scheme. The third crucial piece of evidence is a set of handwritten notes from a 2019 meeting with accountants, notes that lay bare the full extent of the fraud. In these notes, Melania documented a conversation where the defendant explicitly instructed the accountants to prepare two sets of financial statements, one for loan applications showing inflated asset values, and another for tax filings showing lower values. His exact words were, "Banks get the good numbers, IRS gets the bad numbers. That's how you build wealth." This statement alone is a roadmap to understanding the fraud. Two sets of books, two sets of lies, each designed to manipulate different systems for personal financial gain. It's a stunning revelation, and it's all corroborated by Melania's contemporaneous notes. This is where Melania's role becomes so critical to the prosecution. Spouses are often the only ones who are privy to the private, behind-closed-doors conversations that form the foundation of criminal intent. They're there when decisions are made, when instructions are given, when actions are taken. In this case, Melania's notes, recordings, and messages provide a window into the defendant's private, unguarded moments, where he discussed strategies to defraud the very systems that were meant to uphold fairness and transparency. These weren't conversations held in the presence of lawyers or accountants who might later be called to testify. These were private, intimate moments captured in real time, giving prosecutors a rare and invaluable insight into the defendant's state of mind. It's one thing to have a cooperating witness testify about what they saw or heard. It's another to have them present hard evidence that corroborates their words. In Melania's case, the evidence she provided wasn't just complementary to her testimony, it was the linchpin that secured the additional charges. The grand jury didn't just take her word for it, they had the recordings, the texts, and the notes to substantiate her claims. And that's why, after 4 hours of testimony and just 1 hour of deliberation, the grand jury unanimously voted to add 12 more counts to the indictment. This wasn't a case of he said, she said. This was a case built on a foundation of hard, irrefutable evidence. What makes Melania's cooperation so extraordinary is that it wasn't just about helping the prosecution, it was about saving herself. When you face the possibility of decades in prison, as she did, the choice becomes clear. Cooperate or face charges of your own. Federal prosecutors had a mountain of evidence that could implicate her directly in the conspiracy. She had signed loan applications with inflated values. She had attended meetings where the fraud was discussed. She had benefited from the fraudulent loans. Under federal conspiracy law, her involvement, whether as a willing participant or a reluctant accomplice, carried the same potential penalties as the primary defendant. She had to make a choice, face the music with her husband or cooperate and take a deal that would allow her to avoid jail time. The decision was easy for her, even if it was morally complicated. Melania chose the path of cooperation, signing an immunity agreement that would allow her to testify truthfully without the threat of prosecution. This is standard in high-profile federal cases, where the government needs key witnesses to build a case, but also needs those witnesses to testify without fear of retaliation. But the agreement comes with a catch. If Melania were to lie or withhold information, the immunity would be revoked, and she could face the full conspiracy charges alongside her husband. For someone in her position, it was a high-stakes gamble, but one that ultimately kept her out of prison and positioned her as a crucial player in the case against the defendant. As this case unfolds, the implications of her cooperation will continue to reverberate throughout the courtroom. It's clear that her testimony and the evidence she provided are the backbone of the prosecution's case. Without her, the conspiracy charges would likely have remained speculative, lacking the concrete proof needed to secure a conviction. Her role, therefore, cannot be overstated. It's not just that she flipped, it's that her flipping changed the entire course of the trial, turning what could have been a murky, circumstantial case into a clear-cut, slam-dunk prosecution. The precision, consistency, and multiplicity of sources elevate her testimony from mere narrative to irrefutable evidentiary force. All of this, of course, existed within a highly strategic framework orchestrated by federal prosecutors. Timing, coordination, and sequencing of testimony and arrest were executed with precision. By waiting until she was under oath, they neutralized any risk of interference, pressure, or influence. The morning's events were a testament to meticulous planning, highlighting the interplay between evidence collection, legal strategy, and courtroom dynamics. For those watching from afar, it reads like a legal thriller, a coordinated arrest, a cooperating spouse revealing decades of alleged misconduct, and the judicial system moving with methodical, relentless efficiency. The morning was not just about what happened, it was about how it happened, why it happened, and what it signals for the unfolding legal drama.